I'm Tom Brodbeck, filling in for Charles Adler. One of the most important foundations of our criminal justice system is that everybody is equal before the law, without discrimination, particularly when it comes to race, sex, age, religion, or physical disability. It's the cornerstone of any just and credible legal system, that we treat people fairly, decently, and equally, regardless of the color of their skin, their ethnic background, or their economic circumstances. It's what makes Canada such a great country. These laws are protected in the Charter of Rights, Section 15(1) to be precise. It reads the following: every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Despite that, we have a law on the books today that appears to violate that section of the Charter. It's a law that treats people differently based on their ethnic background. It's largely a judge-made law that emanated from Parliament, originally through vague wording, but it's been defined by Canada's judiciary over the years. It's referred to as the Gladue provision, where courts must give special consideration to Aboriginal offenders at sentencing based purely on their ethnic background, instead of treating each offender on the facts of their case, including examining an offender's past, upbringing, and the many events that may have led to a life of crime. Gladue, which is named after a 1999 Supreme Court of Canada ruling, has a different set of rules for Aboriginal people. And those rules do not apply to any member of any other race. As a result, members of other races are being denied their equal protection and equal benefit of the law, based purely on their ethnicity. That's a charter violation. What Gladue does is it forces the courts to consider as mitigating factors the effects of colonialism, residential schools, displacement, and other historical wrongdoings of Aboriginal offenders. But there are no similar provisions in law for the courts to consider the historical wrongdoings of members of other races, including those who may have suffered directly or indirectly from human atrocities such as the Holocaust or Cambodia's Khmer Rouge mass killings in the 1970s. The sentencing provisions apply only to people of Aboriginal descent. That's racism. And unfortunately, we found out recently that Federal Justice Minister Rob Nicholson appears to support this provision, or at least he has expressed no opposition to it when asked to change it. So it's time for some Canadian common sense. I wrote a column in April recommending 5 major changes I thought the federal government should make to improve our criminal justice system. I asked Sun Media readers to send their recommendations to Federal Justice Minister Rob Nicholson if they liked the proposed changes. Some readers did, and Nicholson, nearly 8 months later, finally responded to those. Sadly, Nicholson, in his response, appeared to support the Gladue provision, insisting Aboriginal offenders are subject to the same laws and sentencing provisions as all Canadians, which he knows is factually incorrect. He wrote, and I quote, "All decisions about the sentencing of adult offenders are made by the sentencing judge based on the fact of the case and in light of the guidance provided by the sentencing provisions in the criminal code," end of quote. But the guidance provided by the criminal code, as interpreted by the courts, is to give Aboriginal offenders special treatment. And it's shocking that Nicholson would appear to be in favor of that. The truth is, Parliament's only guidance to the courts on this issue, which came into place in 1995, was for judges to find sanctions other than jail when possible and when reasonable for all criminals based on the circumstances of each case. Then they added these 9 words, while paying particular attention to the circumstances of Aboriginal offenders. Well, what does that mean? Those last 9 words have little to no meaning, but the courts have defined them on their own. And what Canada's top court has ruled is that a Gladue report must be prepared at sentencing for every Aboriginal offender, and the contents of those reports must be considered by the judge, based purely on the race of the offender. Now, the Supreme Court reaffirmed that requirement earlier this year, even admonishing some lower courts for ignoring or glossing over the Gladue provisions over the last few years. Parliament needs to change this. Our lawmakers need to eliminate the provision that calls on the courts to give Aboriginal offenders special consideration. Folks, this is Canada, and and everybody should be equal before and under the law, regardless of the color of their skin. And that's Canadian common sense.